Hi, want to discover something new? Well, today we will be discussing to you the chapter 3 of obligations and contracts. That is all about different kinds of obligations. We will be covering chapter 3 from section 1 to section 3. We will discuss Articles 1179 to 1181 of the Civil Code of the Philippines, which pertain to the concept of pure and conditional obligations. Understanding these provisions is essential in grasping the fundamental principles governing contractual agreements. So here's the question. Ana borrows 5,000 pesos from Ben. They agree that Ana will repay the amount without any specific date or condition attached. Since no condition or future event is required for the obligation to take effect, Ana is immediately required to pay the 5,000 pesos as soon as Ben demands it. In this case, Ana's obligation to pay Ben is pure because it does not depend on any conditions or future event. It is immediately demandable from the moment the agreement is made. This relates to Article 1179, defines pure and conditional obligations. A pure obligation is one that must be fulfilled immediately, as it is not subject to any condition or time limitation. This means that the obligation is absolute and unforceable upon agreement. For example, if a person promises to pay another individual a sum of money without any attached condition, then that payment must be made immediately. Next is Article 1180. If a debtor promises to pay when his means permit him to do so, the obligation is not immediate. Instead, it has a period, meaning payment will happen at the future but certain time when a debtor has enough money. If the creditor feels the debtor is delaying too much, Article 1197 allows the court to set a specific deadline for payment. Common phrases are, when I have money, as soon as I have money, when I can afford to pay. Oh wait, let us now understand what is a condition. So according to Article 1179, a condition has been defined as a future event and uncertain event upon which an obligation is made to depend. It is a future and uncertain event upon which the acquisition or resolution of rights is made to depend by those who execute the juridical act. There are classifications of conditions. The first one is as to the effect of obligation. Under this is suspensive condition, which means the fulfillment of the condition results in the acquisition of rights arising out of the obligation. Next one is resolution condition. This means the fulfillment of the condition results in extinguishment of rights arising out of the obligation. The second type of condition is as to the origin of condition. Under this, we have the protestative, which means the fulfillment of the condition depends upon the will of one of the parties. Example, I will give you my watch if I will go to the shopping mall today. The next category is the casual condition. This means the fulfillment of the condition depends upon chance and or upon the will of a third person. For example, I will give you my only bicycle if it will rain today. The third condition under the same category is mixed condition. It is the fulfillment of the condition depends partly upon the will of a party to the obligation and partly upon chance and or the will of the third person. For example, I will give you my only car if I will go to the shopping mall today and if it will rain today. Now there's actually a rule in a mixed conditional obligation. The existing rule is that when the condition was not fulfilled but the obligor did all in his power to comply with the obligation, the condition should be deemed satisfied. Have you all noticed the difference of the three? Well, if you've already grasped the idea, let's move forward to the third classification of condition, which is as to possibility. Now under this, we have two categories, the possible and impossible condition. Now, when we say possible condition, the condition is capable of realization according to the nature, law, public policy, or good customs. While impossible condition is the condition that is not capable of realization according to nature, law, morals, good customs, public order, or public policy. And it may either be physical or legal. Now we've already identified the three classifications of conditions, which now let's move forward to the fourth one, which is as to mode. Under this are positive and negative condition. When we say positive condition, it involves the performance of an act, while negative condition involves non-performance of an act. Now the fifth condition is as to divisibility condition. There are also two types under this, the divisible condition and indivisible condition. Now, when we say divisible condition, it is susceptible of partial realization or likely to be influenced or harmed, while the indivisible condition is not susceptible of partial realization. Now, the sixth condition is as to numbers. Under this category are conjunctive condition and alternative condition. Both of them are several conditions. The only difference they make is that conjunctive condition, all of which must be realized, while alternative condition is one of which must be realized. Now the seventh condition is as to form. Present in here is the express condition and implied condition. In express condition, the condition is stated expressly, while implied condition is tacit. So again, there are 7 classifications of conditions. The first is as to the effect of obligation. The second is as to the origin of condition. The third is as to possibility. The fourth as to mode. Fifth as to divisibility. Sixth as to numbers. And last is as to form. Now let's move to Article 1181. Have you ever made a promise that depends on something happening first? That's exactly what Article 1181 is about. Article 1181 says that when an obligation is based on a future uncertain event, it only takes effect if that event happens. If it doesn't, the obligation never exists.
Kim, if you pass the exam, I'll give you 1,000.
Really? Challenge accepted.
Here, Honest's promise depends on Kim passing the exam. If she passes, she must pay. But if she fails, she has no obligation at all. A conditional obligation depends on a future uncertain event. If the event happens, the obligation is enforceable. If it does not happen, the obligation never arises.
Next are Article 1182 to 1184. These articles ensure that obligations are based on reasonable and possible conditions, and that obligations cannot be manipulated by one party to their sole advantage. Article 1182 states that when the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon the chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of the Civil Code 1115. Under the definition of potestative condition, in which a condition whose fulfillment depends on the sole will of one of the contracting parties, this article provides that if the fulfillment of the potestative condition depends on the debtor, the conditional obligation shall not be enforceable. On the other hand, if the fulfillment depends on the creditor, it is considered valid and can be demanded. So for example, Sharon told Trexie that she will give her 1,000 pesos on her birthday if she feels like it. Trexie's birthday arrives and Trexie demanded the 1,000 pesos Sharon promised her. So question is Sharon obligated to give Trexie the 1,000 pesos? Answer, no. Because the law states that if the fulfillment of the obligation depends on the sole will of the debtor, then the conditional obligation is not demandable. Next is Article 1183, which talks about impossible conditions. Simply put, this article states that if a contract has an impossible or illegal condition, it becomes invalid. However, if only part of the contract is affected, the rest remains valid. There are 2 kinds of impossible conditions. One in which the conditions are contrary to the law of nature, which is referred to as physical impossible conditions. For example, Joy obliged herself to give John her only house if John can create an invisible chair. The other is called legal impossible conditions, which are contrary to law, morals, good customs, public order, or public policy. Example, Rose promised Mary 100,000 if the latter will inflict serious physical injury to their neighbor Anna. The general rule is that impossible conditions annul the obligation which depend upon them. As a result, both the conditional and the obligation are void. Like for example, Krishna promised to pay Julia 2,000 pesos if she gets the highest score in their law quiz, and an additional 1,000 pesos if she inflicts serious physical injuries to her rival. In this scenario, the part of inflicting serious physical injuries, which is a unlawful condition, is considered void. On the other hand, achieving the highest score, which is not an impossible nor a unlawful condition, remains valid. The second exemption is if the condition is negative, in other words, not to do an impossible thing. It shall be considered as not having been agreed upon. For example, Jean promised to pay Christine 20,000 pesos if she will not create an invisible chair. So lastly, if the obligation is pre-existing and does not depend on the fulfillment of the impossible condition for its existence, only the condition is void. For example, Kelvin has an obligation to give the cell phone that Julius owns back to him. But Kelvin creates a condition that Julius should pay first 10,000 pesos to get the cell phone. In this scenario, the condition is not valid since there was already a pre-existing obligation of Kelvin to the phone back to Julius, since he does not have the ownership of the thing. By means, he is not entitled to make a condition of such. Next is Article 1184, which states that the condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. In simple terms, it says that if an obligation depends on something happening at a specific time, the obligation ends as soon as that time passes and the event hasn't happened. Although there are exemptions to this rule. First, only a part of the obligation that is considered as an impossible or unlawful condition will be void, and the rest will be considered as valid. In this scenario, the condition is not valid, since there was already a pre-existing obligation of Kelvin to give the phone back to Julius, since he does not have the ownership of the thing. By means, he is not entitled to make a condition of such. Next is Article 1184, which states that the condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. In simple terms, it says that if an obligation depends on something happening at a specific time, the obligation ends as soon as that time passes and the event hasn't happened. So for example, Gab promised to pay Mark only if he finishes a job by a certain date. And if he don't finish it by that date, he doesn't have to pay him. Next is Article 1184, which states that the condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. In simple terms, it says that if an obligation depends on something happening at a specific time, the obligation ends as soon as that time passes and the event hasn't happened. For example, Gab promised to pay Mark only if he finishes a job by a certain date, and if he don't finish it by that date, he doesn't have to pay him.
Now let's talk about Article 1185 or the impossible or illegal conditions. Mr. Reyes, a businessman, tells his friend Daniel, I will give you 500,000 pesos if you can build a house on the moon. Daniel, an architect, is initially excited. However, upon realizing that constructing a house on the moon is currently beyond human capability, he understands that condition is impossible to fulfill. According to Article 1185, if a suspensive condition, a condition that must occur for an obligation to arise, is impossible, illegal, or contrary to good morals, then the obligation is deemed never to have existed. In this case, since the condition building a house on the moon is physically impossible, the obligation to pay 500,000 pesos never takes effect. The same rule applies if the conditions were illegal, such as promising a reward for committing a crime. An obligation subject to an impossible or illegal condition is considered void at the beginning. On other hand, is Article 1186 or the voluntary prevention of a condition. A company CEO, Mr. Santos, promises his employee Alex, if you successfully pass the leadership training, I will promote you to senior manager. Eager to advance in his career, Alex enrolls in the training program. However, Mr. Santos, realizing that he doesn't want Alex to be promoted, intentionally removes Alex's name from the list of participants, preventing him from completing the course. Under Article 1186, if the fulfillment of a condition is voluntarily prevented by the obligor, the law treats the condition as if it had been fulfilled. In this case, since Mr. Santos deliberately stopped Alex from completing the training, the law considers the condition, passing the training, as fulfilled. As a result, Alex is legally entitled to the promotion. Moving forward is Article 1187, retroactive effects of conditions. An elderly landowner, Don Carlos, tells his grandson Miguel, I will transfer ownership of my farm to you if you graduate from college. Miguel diligently completes his studies and graduates at 22. Upon meeting the condition, Don Carlos officially transfers the farm to him. However, Miguel realizes that the farm has been generating income from crop sales over the past few years. He now asks, does he have the right to those past earnings? Under Article 1187, when a condition is fulfilled, the effects of the obligation retroact to the moment the obligation was constituted unless stated otherwise. In this case, the obligation to transfer the farm arose when Don Carlos made the promise, but its effect was suspended until Miguel graduated. Since the condition has now been met, Miguel's right to the farm is recognized from the moment the promise was made, not just from graduation day. Therefore, he is entitled to the past earnings of the farm as well. When an obligation is subject to a suspensive condition, its effects may go back to the moment the promise was made, once the condition is fulfilled.
So Article 1188 of the Civil Code of the Philippines states the creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what he has paid by mistake before the fulfillment of that condition. So Article 1188 deals with conditional obligations, specifically the rights of the creditor and the debtor when a condition is pending. So for the creditor, if an obligation depends on a future event, the creditor can take legal actions to protect his right while waiting for the event to happen. This ensures that the debtor does not act in bad faith and try to avoid fulfilling the obligation. And for the debtor, if the debtor mistakenly fulfills the obligation before the condition happens, he has the right to recover what he has paid. This protects the debtor from unfair loss if the condition is never met. So the example explanation for the protection of debt creditor's rights is when Juan agrees to sell his land to Pedro if Pedro wins a government contract. While waiting for the contract, Juan tries to sell the land to another buyer. Pedro can file a case to prevent Juan from selling the land to someone else, ensuring that his right to buy the land is protected if the conviction happens. So the scenario 2 is the recovery by the debtor. So Maria promises to pay Luis 50,000 pesos if Luis passes the bar exam. Before the results came out, Maria mistakenly pays the 50,000. If Luis fails the exam, Maria can demand her money back because the condition or the passing the exam was not met. In legal terms, loss refers to the inability to deliver a specific thing due to its destruction or disappearance without the debtor's fault. In obligations, when the object of the contract is lost or destroyed, it affects the debtor's liability. Loss may extinguish that obligation only under these two certain conditions. 1. The loss is due to fortuitous events or force majeure. 2. The debtor is not at fault or negligent. Imagine, you have a contract to deliver a specific antique vase. One day, while stored in a secure place, an unexpected earthquake hits and destroys it. This is a fortuitous event, and since you took reasonable care, you are not liable, and the obligation to deliver the vase is extinguished. In obligations, loss refers to the destruction or permanent disappearance of the object of the obligation. According to the Civil Code of the Philippines, Article an obligation is extinguished if the specific thing is lost or destroyed without the debtor's fault and before they incur delay. However, if the debtor is at fault or negligent, the obligation remains, and they may have to pay damages. So there are three types of loss. 1. The physical loss. 2. The legal loss. And the 3 is the civil loss. So physical loss is a complete destruction or like a house destroyed by a fire. Legal loss refers to an object becomes legally impossible to deliver, like government seizes the property. And civil loss is the object exists, but the debtor loses ownership or possession, or the stolen property. So example, John agrees to deliver a rare one-of-a-kind painting to Maria. Before the delivery date, the painting is destroyed in a warehouse fire caused by lightning. Since the loss occurred due to a fortuitous event and without John's fault, his obligation is to deliver the painting is extinguished. Today, we're going to talk about usufruct, a legal concept that allows someone to enjoy and use another person's property while preserving its substance for the owner. In simple terms, a usufruct is a legal right granted to a person, called the usufructuary, to use and enjoy the property owned by another person. The naked owner, without altering its essential character, the usufructuary can benefit from the property's fruit, such as rental, income, or harvest, but must return the property in its original state once the usufruct ends. The usufruct can be created through a contract, a will, or by the law. It can be for a specific period, for the lifetime of the usufructuary, or until a condition is met. However, it comes with obligations. The usufructuary must take care of the property and cannot sell or destroy it. Example, let's say Maria's father owns a rice field. Before he passed away, he gave Maria the usufruct of the rice field for 10 years. This means Maria has the right to cultivate the field, sell the rice, and keep the profits for herself. However, she must maintain the field, make necessary repairs, and return it to her father's estate in good conditions after 10 years. She cannot sell it the land because she is not the owner. She is just the usufructuary. If Maria fails to take care of the field or uses it in a way that damages its value, the naked owner or the heir can take legal action to protect their rights.
Hello, I will be discussing Articles 1190 and 1191, which covers the effects of reciprocal condition and the breach of reciprocal obligation in contracts. Article 1190 explains that an obligation subject to reciprocal condition remains valid until the condition occurs. Once it happens, the obligation is terminated and both parties must return what they receive. If the object involved is lost, damage, or improve, liability is determined based on Article 1189. But what exactly is regulatory condition? It is an event that, when it occurs, ends an obligation or contract. This applies not only to obligation to give, but also obligation to do and not to do. When a reciprocal condition is fulfilled, the effects vary depending on the type of obligation. For an obligation to give, both parties must return what they receive. If the object has deteriorated, the responsible party may need to compensate for the damage. If it has improved, the owner benefits from the improvement. In an obligation to do, the party required to perform an act is no longer obligated to do so. Meanwhile, in an obligation not to do, any restriction is lifted allowing the person to do what was previously prohibited. For example, imagine a student receiving a scholarship under the condition that they may maintain a certain grade. As long as they made that required grade, they continue to receive financial support. However, if their grades drop below the required level, the scholarship is revoked and they may have to return any unused funds or lose future financial aid. This situation reflects Article 1190 because the scholarship remains valid until the condition, which is maintaining the grades, is broken. Once that happens, the school's obligation to provide financial aid ends. Now, let's move on to Article 1191, which deals with breach of reciprocal obligation. Article 1191 applies to reciprocal obligation where both parties agree to performing something for each other. If one party fails to fulfill their obligation, the injured party has two choices. They may either demand the fulfillment of the obligation or rescind or cancel the contract with the right to claim damages if necessary. However, rescission under Article 1191 is not automatic. The injured party must go to court to request rescission unless the contract expressly allows extrajudicial rescission. Courts may also grant a grace period if the breaching party shows valid reason for their non-compliance. So rescission means that a contract is cancelled and mutual rescission must take place. This means that both parties must return what they have received. Object is lost or damaged, the responsible party must need to compensate the other party. If the contract is rescinded and improvement has been made, the owner benefits from the improvement. For instance, if Anna agrees to sell her car to Ben for 500K, but Ben refuses to pay after Anna delivers the car, Anna can either demand the payment or cancel the sale and take back the car. If Ben already used the car and caused damages, he may also be reliable for the compensation. There's also a situation where a contract can be cancelled without going to court, known as extrajudicial rescission. This applies when the contract expressly allows rescission of its breach, is clear and substantial. However, if the other party disputes the rescission, it may still end up in court. Aside from the rescission, the injured party has alternative remedies. They can demand specific performance, meaning the breaching party must fulfill their obligation. They may also claim damages without canceling the contract if they still benefit from it but want compensation from the breach. Now let's discuss Article 1192, which addresses situation where both parties are at fault in a reciprocal obligation. Article 1192 states that when both parties have committed a breach of obligation, the court will determine the extent of each party's fault and equally reduce their respective liabilities. If it is impossible to determine which party is more at fault, the contract is considered extinguished and both parties bear their own losses. The application of Article 1192 ensures fairness when both parties fail to comply with their obligations. The court evaluates the circumstances to determine the degree of fault of each party. If one party is found to be more at fault, their liability will be greater while the other party's liability is reduced proportionally. However, if both parties are equally at fault, the contract is terminated and neither party can demand restitution from the other. For example, suppose a company hires a contractor to build an office, but the contractor fails to meet the agreed upon deadline. Meanwhile, the company also fails to provide the necessary materials on time. In this case, since both parties failed in their obligation, the court may decide how to adjust their liabilities based on the degree of their faults. If the contractor's delay was greater than the company's failure to provide materials, the contractor might bear a higher portion of the liability. Another example would be a lease agreement where a tenant fails to pay rent, and the landlord also fails to maintain the property as agreed. In this case, if the breaches are of equal significance, the lease might be considered void without further obligation. If one party's breach is more severe, the other party may receive compensation or other legal remedies. By including Article 1192, we see that reciprocal obligations are not always straightforward. When both parties fail to meet their obligation, the court step in to ensure fairness and prevent unjust enrichment. The principle behind this article is that no party should unfairly benefit from a breach while the other suffers a disproportionate loss.
Hey everyone! Today, let's talk about Articles 1193 and 1194 of the Civil Code of the Philippines. These articles deal with obligations that depend on a period or condition. Article 1193, obligation with a period versus obligation with a condition. What's the difference between the period and a condition and obligation? According to Article 1193, obligation can be classified into three. First is pure obligation, no condition or period demandable at once. Obligation with a condition, it is a fulfillment, depends on a future and uncertain event. The third is the obligation with a period. It is a performance is subject to a future and certain event. Let's proceed to the conditional obligation or the future and uncertain. The obligation only takes effect or is extinguished when a future uncertain event happens, can be suspensive or resolutory. For example, I promise to give my brother 100,000 if he passes the bar exam. The obligation only arises if he actually passes. This is what we call the suspensive condition. Let's proceed to the obligation with the period or the future uncertain. The obligation will definitely happen, it's just a matter of when. Can be suspensive or resolutory. For example, I agree to pay a supplier 50,000 on December 1. The obligation already exists, but can only be demanded when the date arrives. Now let's move on to Article 1194, which explains what happens if something is lost, damaged, or improved before the period arrives. First, if the object is lost without fault of the debtor, the obligation is extinguished, debtor is not liable. If the object is lost with fault of the debtor must pay damages. Third, if the object deteriorates without fault of the creditor must accept it as is. Fourth, if the object deteriorates with fault of the creditor can choose between resolving the obligation or demanding damages. Fifth, if the object improves by nature or time, the improvement benefits the creditor. Last, if the object improves by the debtor's effort or expense, the debtor has no right to reimburse unless the contract says otherwise. For example, let's say I agree to deliver a rare painting to a buyer in 6 months. If the painting is destroyed due to an earthquake, the obligation is extinguished, no one is at fault. If I accidentally damage the painting, I am liable for the damages. If the painting increases in value, the creditor benefits without extra payment. To summarize, Article 1193 differentiates between obligation with condition or uncertain future events and those with period certain future events. Article 1194 explain what happens if an object is lost, damaged, or improved before the period arrives.
Hello everyone, today I'm going to explain to you Article 1195 and 1196 of the Civil Code of the Philippines. These articles deals with obligation involving the period and what happens when payments are made before the due date. Let's break them down one by one. Article 1195, Recovery of Payments Before the Due Date. Anything paid or delivered before the arrival of the period, the obligor being unaware of the period or believing that the obligation has due and demandable, may be recovered with fruits and interest. So what does Article 1195 say? If someone pays or delivers something before the agreed period and they were unaware of the period or mistakenly through the obligation was already due. An obligor can recover a premature payment if they were unaware of the period or mistakenly believed that the obligation was due. They may reclaim the principal amount, any fruits, and interest. However, recovery is not allowed if the payment was made knowingly before the due date or if the obligation was subject to a resolutory condition instead of a fixed term. Article 1196 protects both parties from premature demands unless the term is waived. Understanding these provisions helps ensures the contractual obligations are met correctly within the legal framework. So Article 1196 protects both parties from premature demands unless the term is waived. Understanding these provisions helps ensure a contractual obligations are met correctly within the legal framework. The article ensures that individuals who mistakenly make premature payments can recover their money, fruits, and interest provided the payments was not made voluntarily with full knowledge of the period. Understanding the provisions helps ensures contractual obligations were fulfilled correctly within the legal framework. Now let's move on to Article 1196, Creditors' Rights to Demand Payments Before the Due Date. Article 1196 states that if an obligation is subject to a period or establishment, a creditor cannot demand early fulfillment of an obligation unless the debtor waives the benefit of the term. Similarly, the debtor cannot be forced to pay before the due date unless such a waiver occurs.
In Article 1197, the court is not authorized to fix a period. That is the general rule. However, there's an exception. First, if the obligation does not fix a period, but its nature circumstances, it can be inferred that a period was intended. Second, if the period depends upon the will of the debtor. Third, if under the circumstances, the parties have contemplated a period. Fourth and lastly, when the debtor binds himself to pay when his means permit him to. Now let's move on to Article 1198. This article states that even a debtor was given a period to fulfill an obligation, they can lose that right in certain situations. So, when does the debtor lose the right to the period? If the debtor becomes insolvent or goes bankrupt unless security is provided. Also, if the debtor fails to fulfill other obligations under the same contract. And if the debtor tries to evade payment. And lastly, if security given by the debtor is lost due to their fault. So here's an example scenario. So, here's the example scenario. Imagine X lends someone 500,000 and they agreed to pay back in 1 year. But after 3 months, X declared bankruptcy and won't have the ability to pay back. So, because he is now insolvent, the debtor can demand full payment immediately, even before the 1 year period ends. So, in Article 1198, it states that the debtor shall lose every right to make use of the period when, after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or security for the debt. And also, when he does not furnish to the creditor the guarantees or securities which he has promised. And also then, when by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear unless he immediately gives new ones equally satisfactory. And lastly, the debtor will lose when the debtor violates any undertaking in consideration of which the debtor agreed to the period. Lastly, when the debtor attempts to absorb.
Now, in an obligation, there are alternative ones. First is the kind of obligation according to object, the simple and compound obligation. When we say simple, it refers to only one subject. For example, X bound himself to deliver his only dog to Y, and D owes C 5,000 pesos. On the other hand, a compound obligation includes two or more objects. Then, there are kinds of compound obligation. First is the conjunctive obligation. Two or more objects and all of them are due, then it must be performed to extinguish obligation. So here, X must give Y his phone, laptop, and TV on August 1, 2020. So if he fails to deliver any, the obligation remains because the rule is complete payment, complete performance. Next is distributive obligation. An obligation where one or more objects are due, but performing just one is enough to extinguish it. Moreover, there are kinds of distributive obligation, the alternative and the facultative. When I say alternative, it is when more than one objects are due but the performance of one is sufficient or enough. X is obliged himself to give his cell phone or laptop or his TV to Y on December 31, 2020. The delivery of either of these will extinguish the obligation. Next is the facultative obligation is when only one subject is due but the debtor substitute another object. X must give Y his land but he can substitute it with his car. Delivering either will extinguish the obligation.
I will be discussing Article 1199 to 1202. First, Article 1199. X is obligated to deliver either his only cell phone, laptop, or TV to Y on December 31, 2023. On the due date, X chose to deliver his cell phone, but refused to include the charger, earphones, and owner's manual. Y rejected the delivery, claiming it was incomplete. Is Y legally justified in refusing the delivery? Yes, Y is legally justified in refusing the delivery. Under Article 1199 of Civil Code, a debtor with an alternative obligation must completely perform one of the chosen prestations. However, under the principle of the complete payment of performance, when an item has necessary accessories, this must also be delivered. A person alternatively bound must fully perform one prestation. The creditor cannot be forced to accept an incomplete performance. Next is Article 1200. X owes Y either a specific phone or a specific laptop. Their agreements say X gets to choose which item to give. Who has the right to choose whether X gives the phone or the laptop? X has the right to choose. Under Article 1200, the right of choice is an alternative obligation belongs to the debtor unless it has been expressly granted to the creditor. In this scenario, the agreement states X gets to choose, so X holds the right of election. Next is Article 1201. X owes Y either a specific phone or a specific laptop. X texts Y, I've decided to give you the phone. Can X now change his mind and give the laptop instead? The answer is no. X cannot change his mind. Under Article 1201, once the choice of which item to give is communicated to the other party, the choice becomes irrevocable. X, having clearly communicated his decision to give the phone, is now bound by that choice and cannot switch to the laptop. Next is Article 1202. X owes Y either a specific phone or a specific laptop. The phone is accidentally destroyed in a fire. What must X give to Y to fulfill his obligation? The answer is X must give the laptop. Under Article 1202, with the phone destroyed, X is obligated to deliver the remaining laptop.
I will be discussing the Articles 1203 to 1205. First is the Article 1203. Jake owes Lisa and can pay either in a cash or by giving his bike. However, Lisa takes Jake's bike without permission, leaving him no choice. Under the Article 1203, Jake can rescind the contract and claim damages because Lisa's action prevents him from choosing his payment method. Moving on, Article 1204, Marx owes Sarah and pay either by giving his car or his motorcycle. However, due to Mark's negligence, both the car and motorcycle got damaged beyond repair. Under the law, Article 1204, since Mark's fault made it impossible to fulfill the obligation, Sarah has the right to claim damages from him. Lastly, the Article 1205. Marx owes John and has option to pay with either a bicycle or 12,000 pesos. This agreement states that John, the creditor, has the right to choose. Then one day, John tells Mark, I choose the bicycle. Under the law, Article 1205, from the moment Mark can no longer pay with 12,000, he must give the bicycle because the obligation is no longer alternative.
So here, X promised Y his laptop but later chose to give his phone instead. Before the due date, the phone was lost due to a fortuitous event. Is X liable? No, X is not liable. Under Article 1206, after substitution, the new object becomes their obligation. If lost due to fortuitous event, the obligation is extinguished. Since X had already replaced the laptop, he is not responsible for the phone's loss. For example, X promised to give his only laptop to Y. He also agreed that if he couldn't deliver the laptop, he would give his cell phone as a substitute. So before the substitution, before the due date, X's cell phone was lost due to his negligence. Y demands the laptop, but X refuses, arguing that the cell phone was meant as a replacement. So is X still obligated to deliver the laptop? Well, yes, X must still deliver the laptop. The cell phone was not yet officially substituted, so the main obligation remains the laptop. And what if the cell phone was lost due to a fortuitous event? So X must still deliver the laptop. A fortuitous event does not affect the obligation because no substitution was made. If the laptop was lost instead, or lost due to a fortuitous event, the obligation is extinguished. But if it was lost due to X negligence, X is liable for damages because it doesn't affect the obligation because no substitution was made. Now, after the substitution, a few days before the due date, X informed Y that he would deliver the cell phone instead of the laptop. Before the delivery, the cell phone was lost due to X negligence. So X still liable for damages? Yes, X is liable because after the substitution, the obligation is no longer facultative but a simple obligation. When the cell phone asks the object, since X was negligence, he must pay for damages. And what if the cell phone was lost due to a fortuitous event? Well, no, the obligation is extinguished. If the cell phone was lost to a fortuitous event, X is not liable because the obligation no longer exists.